Done. One word. That was the tipping point according to the official court records. A single word from a judge who had finally reached his breaking point. The defense lawyer stopped mid-sentence. The room fell into a dead hush, and the cameras captured a moment legal experts are calling the most explosive courtroom scene of the year. This is a court of law, not a campaign stop, not a media spectacle. My bench. According to recently unsealed court documents, the defense had been testing the limits for weeks, playing to the lens instead of the jury. But on this specific day, documented on page 247 of the transcript, the judge did something no one anticipated. He took command, and he didn't offer an apology. So, what finally snapped the judge's patience? One moment, one choice, one boundary the defense should never have crossed. Based on court filings released just last week, the defense attorney stood up during a vital phase of testimony and began what observers described as a partisan monologue, complete with nods to outside probes, media narratives, and what the transcript labels as inflammatory rhetoric that had zero relevance to the evidence. But here's the reality. This wasn't an accident. This was weeks of boundary pushing finally coming to a head. The paperwork reveals a clear pattern going back to the very first pretrial hearing, where the judge issued his initial caution regarding courtroom behavior. The defense dismissed it. The second caution came during jury selection. Dismissed again. The third warning, recorded in a once private sidebar, now made public, included a direct ultimatum. One more outburst and I will intervene. And I'm going to walk you through exactly how it all collapsed, document by document, warning by warning. The scene everyone is talking about is coming, but first you have to see what the defense did to deserve it, because according to these files, this wasn't a case of judicial overreach. This was a judge doing exactly what the law requires. Here is what actually took place the second everyone clicked to watch. Tuesday morning, 9:47 a.m., Courtroom 4B. The atmosphere was already electric, according to several witnesses quoted in local legal coverage. The prosecution had just finished introducing a crucial piece of forensic data, methodical, professional, and strictly by the book. Then the defense attorney rose. According to the official record, he didn't mention the evidence. He didn't dispute the science. Instead, he turned slightly toward the gallery, where the cameras were focused, and launched into what the court log describes as a lengthy narrative speech. Your Honor, what we are seeing here is part of a much broader scheme. The judge's voice cut him off instantly. Counsel, do you have a legal objection to the evidence presented? I'm establishing a foundation, Your Honor. You're establishing something. It isn't a foundation. The gallery shifted uncomfortably. Court stenographers noted audible gasps. The defense lawyer pressed on anyway. That's when it happened. According to the transcript, page 247, lines 12 through 34, the defense attorney cited ongoing probes in other states, claimed the prosecution was politically driven, and used the term witch hunt 3 times in less than 2 minutes. The judge's gavel struck the bench hard. Once, twice, 3 times. Counsel, sidebar, now. What occurred at that sidebar is now part of the public file. The judge's words were caught by the court reporter. I have cautioned you repeatedly. This is a court of justice. We deal in facts, testimony, and legal merit, not talking points, not sound bites, and not whatever performance you're rehearsing for your press conference later. The defense lawyer reportedly replied, Your Honor, I am merely representing my client's interests. The judge's retort, recorded word for word, No, you're putting on an act, and I'm closing the curtain. Return to your desk, address the facts, or remain silent. Those are your only choices. The courtroom went completely still. According to witnesses, the defense attorney's face turned white. He stood motionless for nearly 4 seconds, a lifetime in a trial. But here's the part no one saw coming, what the full transcript reveals. The defense lawyer didn't sit down. He doubled down. Your Honor, with all due respect, I believe the record should show... The gavel came down again, even harder this time. The record will show that you have been warned 4 times about your conduct. The transcript will show I have demonstrated immense restraint, and the record will now show it ends here. He leaned in, every gaze in the room fixed directly on him. This is my bench, not a partisan stage, not a stump speech, not a broadcast set. You will behave as a professional of this bar, or you will face a contempt charge. There is no middle ground. There is no appealing this caution. Do you understand me? Per the official record, the defense lawyer answered with just 3 words. Yes, Your Honor. He took his seat. The state continued. Formal logs indicate the rest of the day's trial went on without another interruption. No more lectures, no more mentions of external probes, no more acting for the lens. The judge achieved in 90 seconds what weeks of admonitions failed to do. He made it clear who runs the room. If you're seeing this and thinking, at last, a judge who keeps control, click subscribe. This narrative has depths the news isn't reporting, and I have the legal files to back up every point I'm raising here. But not everyone agrees with that view, and frankly, their position is more compelling than you'd expect. The defense side and their advocates are labeling this a case of judicial overstepping. Before you ignore them, listen to this, because parts of their argument actually hold water. A veteran defense lawyer with over 2 decades in the field, unaffiliated with this trial but reviewing the records, said it like this: vigorous advocacy isn't just allowed, it's mandatory. Lawyers have a moral duty to battle for their clients with every legal weapon in the arsenal. When a judge silences that voice, even if it seems over the top, it should worry everyone. Today, it's this lawyer. Tomorrow, it could be you. That carries weight. That's a valid concern rooted in years of law. The online world is divided. Thousands of users are claiming the judge showed favoritism, that he's been tougher on the defense than the state since day one, and that this blow-up exposes his real opinion of the case. And this is where it gets messy for those cheering the bench. According to trial observers who have followed every hour, the state has made comparable edge-pushing remarks, mentions of the defendant's traits, hints at other alleged crimes, and received much milder rebukes. One legal analyst tracked 7 times where the prosecution's overstepping was met with a private sidebar rather than a public scolding. There is a trend here, one pro-defense expert observed. When you compare the public tongue lashings to the private talks, there's a clear gap. That is exactly what an appellate court examines with a magnifying glass. Even unbiased onlookers, the reporters at the trial every day, admit the judge might be legally in the right, but the perception is messy. Shaming a defense lawyer publicly before a national audience builds a specific story. Some see a firm hand, others see a tilted scale. The reality likely demands viewing the entire trial, not just this viral moment. Constitutional experts are asking a deeper question. A professor at a top-tier law school with experience in the appeals system put it this way: judges have massive power to manage their rooms. That's how it works. But that power can become a tool of bias if it isn't used fairly. The issue isn't whether the judge has the authority to do this. He does. The issue is whether he should, and if he would treat the opposition the same way. So, let me be plain. I'm not here to choose a side. Is the judge truly reinstating order and guarding the trial's fairness? Perhaps the records support that view. Or did he overstep in a way that silences a fair defense? That is also a possibility, and there are facts to support that take as well. The truth is likely found in the middle, and that's why it's vital to look at this case closely. What I can share is what the paperwork actually reveals, and the files show a trajectory of growing tension that was headed straight for this climax. But this wasn't an isolated incident. A month and a half before this outburst, the red flags were visible, recorded in pre-trial motions and hearing logs. During the very first conference, the judge established what he termed the ground rules. Per the documentation, he explicitly banned monologues, partisan remarks, or mentions of facts not in evidence. The defense filed a protest. It was shot down. A former magistrate who looked at the early records said something that should have served as a wake-up call. This judge was clearly setting hard boundaries from day one. Any seasoned lawyer would see that as a signal. Push at your own peril. Did the defense pay attention? The documentation implies they did not. During the jury pick, the defense lawyer delivered what the record calls a lengthy speech about the partisan environment. The judge cut him off. Strike two. During opening remarks, another boundary was tested. Another caution, this time more severe. Logs indicate that every week the defense pushed a bit further. Every time they received a warning instead of a penalty. Until that Tuesday morning when their luck ran out. The trend in the paperwork is undeniable. A judge attempting to keep order, a defense team testing the walls, and a certain crash that everyone should have anticipated. One court watcher who has tracked trials for 15 years said it plainly. This judge handed them more slack than most. They decided to trip over it. The stage was set. The defense simply didn't notice they were out of chances. Give a thumbs up if you see the direction this was moving. The trend in these files is perfectly clear, and we haven't even touched on what occurred after the judge's scolding. That's where the narrative gets truly fascinating. And then it happened. Tuesday, 9:52 a.m., room 4B, 5 minutes following the day's first caution. According to the transcript, the audience was still absorbing the judge's earlier remarks. The defense lawyer had just sat back down. The state was getting ready to call the next witness. Then the lead defense attorney stood up once more. "Your Honor, before we continue, I have to make a record." The judge's reply was instant. "You can make legal objections when they are timely." "This is timely, Your Honor. I am noting for the file that this court has consistently—" The gavel. "Counsel, I just explained this. Were you not listening?" "I heard you, Your Honor, but my client has protections, and one of them is—" "Your client's protections are being upheld by these rules. Your behavior isn't protecting anyone. It's creating grounds for appeal. Now take your seat." The official log records a 4-second silence. The defense lawyer sat, but according to observers quoted in later coverage, his expression told a different tale. Defiance, irritation, the look of a person who believed he was right and was being gagged. Regardless, the judge spoke to the room. "Let me be plain for everyone here, the press included. This trial will be ran according to the rules of evidence and law. Period. Anyone, and I mean anyone, who tries to turn this event into something else will face the music. There will be no more cautions, only penalties." 17 seconds. That's all it took. 17 seconds to assert control so absolute that, per the rest of the day's transcript, not one objection was raised for the next 3 hours. But here is what everyone missed while focusing on the fireworks. According to sidebar notes unsealed later, the judge also told the state, "This goes for both sides. Don't push me." A fair warning in both directions. That specific detail didn't make the viral clips. Stay right there. What I am about to disclose changes how you should view the whole situation. Leave a comment. After hearing both sides, which case is more convincing? The judge keeping order, or the defense alleging overstepping? Legal experts who focus on judicial ethics and trial law are calling this a textbook case in courtroom oversight. One former federal judge, someone who handled high-profile cases for 18 years, analyzed it. What you are seeing is a judge who decided that protecting the trial's fairness mattered more than staying out of the spotlight. That takes guts. Most judges would give endless warnings to avoid this kind of press. He set a limit and stuck to it. To put that in simple terms, judges typically take the easiest path. This one didn't. A defense attorney with 20 years of federal trial experience added a vital point. "I've felt the weight of a judge's irritation before. It's never a pleasant spot to be in. But reviewing this transcript, I can't argue that the defense didn't bring it on themselves. There is a difference between fighting hard for a client and disregarding direct instructions. Those are two separate things." Here is what former district attorneys are talking about in private circles. This establishes a benchmark, not necessarily in law, but in the culture of the court. Other benches are watching. Other trial lawyers are watching. The takeaway is obvious. Political theater has its limits in a federal building. Some will applaud that. Others will find it concerning. But it isn't just one side. Even civil rights groups are weighing in. We must always stay alert regarding judicial power, but we also require courts to actually function. A trial where lawyers can just ignore the bench doesn't protect anyone's due process. It just creates a mess. The balance here is truly difficult to strike. A constitutional professor from a top-tier law school provided the most balanced perspective. The judge acted within his power. The defense acted within their rights to push back. Both statements can be accurate. What matters now is the opinion of the appeals court. If an appeal is filed, that's where the actual precedent is set. The legal consensus, and this is a rare sight, seems to be that this judge walked a razor's edge, and whether he stayed on it depends on who you ask. Smash that like button if this legal analysis is helping you grasp what is actually at stake here. This is about more than just a viral moment. It's about how our entire legal system operates. Like the video if you want more breakdowns like this. So, what does this actually signify for you personally? Right now, legal teams across the country are studying this case. According to legal journals, at least a dozen major trials currently in progress involve defense teams using similar strategies, playing to the press, citing external probes, and leaning into political narratives. But here's the reality. If you ever find yourself in a courtroom for any reason, this impacts you directly. Here is why. The line between aggressive representation and courtroom discipline determines if you get a fair trial or a circus. If judges are too restrictive, your lawyer can't fight for you. If they are too permissive, the opposition turns your case into a media spectacle at your expense. Trials that turn into political theater take more time, much more time. According to studies on court efficiency, cases with significant attorney misconduct last 40% longer on average. What does that do to your bank account? Longer trials lead to higher expenses for everyone, including the taxpayers who fund the public defenders and the court staff. If you are ever tied up in a civil lawsuit, every extra hour in that room is money out of your pocket. If you are a business owner, a property manager, or anyone who might face a lawsuit, you should care a lot about judicial efficiency. Here is the bigger picture that should worry us all, regardless of your politics. If this judge's style becomes the norm, it results in cleaner trials, but it also grants more power to judges over how lawyers behave. Every time you hire counsel, the judge's personality matters just as much as your lawyer's talent. Let me give you a concrete example. Imagine you are wrongly accused of a crime. Your lawyer wants to highlight the political context of why you were targeted. The judge says, no, that's a political speech. Suddenly, your defense is hampered. That isn't fear-mongering. That is the legal reality of increased judicial control. Now, I'm not offering legal advice, but here's what informed citizens are weighing. If you are ever summoned for jury duty in a major case, understand that what happens inside that room is often very different from what hits the headlines. If you are ever a party in a case, ask your lawyer point blank, what is this judge's reputation for running their room? Pay attention to judicial elections in your area because the person on that bench decides how these balances are struck. And here's the thing that no one in the mainstream media wants to admit. We want judges to have total control of their courtrooms until they control something we care about. Then suddenly it's labeled overreach. Think about it. If this judge had silenced a prosecutor for making a political speech, the same people who are angry now would be cheering, and vice versa. That inconsistency, that is the real issue with how we discuss judicial authority. If you care about fairness, you can't only care when it helps your team. And then the defense team gave a statement outside the building and made the whole situation more complicated. According to footage from the court steps recorded within an hour of the morning session, the lead defense lawyer held a snap press conference. Rather than moving forward, he chose to double down. What you saw today wasn't an exercise of legal power. It was judicial overreach. Our client is being stripped of his basic right to a robust defense. The public response was instant and divided. The video took off. 3 million hits in the first 12 hours. Comment threads turned into war zones. But here is the part that is worrisome. Per court documents filed the next morning, the state asked for penalties against the defense for trying to litigate the case in the press. The filing pointed directly to the news conference. The defense submitted a cross motion alleging judicial prejudice and calling for the judge to be removed from the trial. The judge's written reply, "Motion dismissed. We are moving forward." A legal expert observed, "This has become a battle. It isn't about the facts now. It's about owning the story. And battles have victims." The state's most recent filing, sent just days ago, the defense's ongoing public remarks sabotage this trial and show the exact behavior the bench has already warned against. The defense's retort, "We won't be gagged. Our client is entitled to a complete and just defense, not a silenced one." This is not over. It's heating up, and the next hearing on the motions is set for next week. But here is what is weighing on me, and I've scrutinized every public record. Why did the defense hit this hard on this specific day? The timing looks intentional. Based on the court schedule, a significant procedural decision was due that afternoon. Was this a tactic? Were they aiming to trigger this exact reaction to set up an appeal? Insiders on the case are hinting the defense might be creating a log for future relief, claiming that judicial favoritism blocked a fair trial. The judge has slated a private hearing with both sides for next Tuesday. No lenses, no reporters. The agenda, per the court record, case oversight and attorney behavior. Whatever occurs behind that door remains private. At the same time, the defense has hired a different lawyer, an expert in judicial ethics complaints. Based on legal news reports, that isn't a step you take if you want to lower the temperature. The judge has supposedly told all personnel to send press questions to the court's media office only. Something is brewing under the radar, and judging by the timing of these documents, both parties are gearing up for a battle much longer than the trial itself. The issue is, who gives in first? Subscribe now because this narrative is just beginning. The second those private hearing logs are released, I'll analyze them. Enable notifications. You won't want to miss what happens next week. Here is the current status. As of now, the trial continues. Both teams are still offering evidence, but the vibe in the room, per reporters who have been there every day, has completely shifted. The defense is clearly more restrained. Their objections are short and procedural. The partisan talk has vanished, at least while court is in session. The state has also softened some of its descriptions. Whatever the judge told them in private, it appears to have worked. But here is what hasn't hit the official records yet. Based on court insiders, and I want to be plain, this is not yet documented, both legal teams have been observed meeting individually with court administration. The purpose of those huddles is a mystery. Critical dates ahead. Next Tuesday, the private hearing on lawyer conduct. The week after, the expected end of the state's case. In 2 weeks, the defense begins in full. Possibly 30 days from now, a verdict, if there are no further holdups. The jury has been told to skip all media news. Whether they are following orders is anybody's guess. The timer is running toward a judgment, but the actual story may be the aftermath. But here is the thought that keeps returning to me after looking at all this. This judge set a boundary that most others wouldn't. At first glance, it appears to be a straightforward exercise of legal power. But cases like this rarely conclude where we expect. If an appellate court detects prejudice, the whole thing flips. If they see proper oversight, this judge becomes the standard. If the defense's press strategy pays off, the public view changes. If it fails, their client pays the price. The truth. It depends on which files you study and how you interpret them. Is this judge a champion of court ethics or a barrier to a fair defense? The answer could be both. It could be neither. The reality is still surfacing. A verdict hasn't been reached on the trial or the judge's behavior. Here is my promise. I will keep monitoring the filings, I will stay on top of that private hearing next week, and I will continue to explain what it signifies without pushing an opinion. Subscribe if you want the whole story, not just the highlights. Turn on notifications because this case is showing us something vital about authority, the law, and who actually owns the narrative. I'll see you in the next video.